The United States Constitution prevents the government from intruding on many of our intimate decisions. But what about one of the most intimate decisions of all, when and how to die? This is the question the Supreme Court was forced to grapple with in Washington v. Glucksberg. In 1854, Washington state enacted a statute criminalizing assisted suicide, including physician-assisted suicide. Over a century later, Harold Glucksberg, a doctor who practiced medicine in Washington, challenged the modern version of that law. Glucksberg argued that the liberty interest protected by the Due Process Clause of the 14th Amendment included a fundamental right to assisted suicide. Glucksberg described the liberty interest more broadly as a right to die. The district court agreed with Glucksberg and held the statute unconstitutional. On appeal, the Ninth Circuit affirmed. The United States Supreme Court granted cert. The question was whether the liberty interest protected by the Due Process Clause of the 14th Amendment included a fundamental right to assisted suicide. Writing for a unanimous court, Chief Justice Rehnquist held that there is no fundamental right to assisted suicide protected by the Due Process Clause. The court applied a two-part analysis to determine whether the right to assisted suicide was a fundamental right. First, the court asked whether the right was deeply rooted in the nation's history and traditions. The court observed that Washington state's assisted suicide ban was not unique. In fact, similar laws existed in almost every other state in the country. Further, the tradition of criminalizing or prohibiting assisted suicide originated in the common law, extending as far back as the colonial period. Therefore, the court concluded that the right to assisted suicide wasn't deeply rooted in the nation's history and traditions. Second, the court examined the description of the asserted right to determine if it was sufficiently particular. The court disagreed with Glucksberg's characterization of the right at stake. Glucksberg described the right too broadly as a right to die, which wasn't a sufficiently particular description. Rather, the court viewed the right at stake more narrowly as the right to assisted suicide. On this point, the court clarified the scope of a fundamental right recognized in an earlier case, Cruzan v. Director, Missouri Department of Health. In Cruzan, the court had recognized that a person in a persistent vegetative state has a right to be taken off life support. According to the court, Cruzan was frequently depicted as recognizing a broad right to die. However, the court explained that the fundamental right in Cruzan was the narrower right to refuse life-saving medical treatment, not a general right to die. The court reasoned that forced medical treatment constituted a form of common law battery, and therefore the right to refuse medical treatment, unlike the right to assisted suicide, was deeply rooted in the nation's history and traditions. Because there was no fundamental right at stake, the court applied the rational basis test to the law. This test asks whether the law is rationally related to a legitimate state interest. The court found that Washington had a legitimate interest in preserving life and protecting public trust in the medical profession. Further, these interests were rationally related to the ban. Washington was reasonably concerned that physician-assisted suicide would cause more deaths, erode public trust in the medical community, and create opportunities for coercion, error, and abuse when treating terminally ill patients. Therefore, the court held that Washington's assisted suicide ban didn't violate the Due Process Clause and reversed the Ninth Circuit. Justice Souter concurred in the judgment, elaborating on what he perceived was Washington's strongest interest in preserving human life. He noted that it was legitimate for the legislature to be concerned that physicians might administer life-ending medications out of their own compassion for suffering patients, or because of financial concerns, even if the patient didn't request the procedure. Justice O'Connor wrote a concurring opinion to argue that because there's no constitutional right to suicide, there's no need to consider the narrower question of whether there's a constitutional right to physician-assisted suicide. She also emphasized that the law at issue did permit terminally ill patients to receive pain-relieving medication, even at levels that increased the speed of death. If a law were to prohibit this palliative care, O'Connor suggested that she might reach a different conclusion. In Glucksberg, the court declined to recognize a constitutional right to die. The decision drew a hard line between refusing life-saving treatment, which is constitutionally protected, and accepting life-ending treatment, which is not.